In a surprising turn in a local stand your ground case, the alleged victim tells the court he has no fear of the teenager accused of shooting him and wants the charges dropped. So why is Marquise Gunter still behind bars in Lamar County on a $750,000 million bond? Here's the I-Team, Cynthia Gould, as she continues digging for those answers.
A stand your ground case involving a teenage suspect from Sulligent is drawing new scrutiny as the alleged victim himself tells the court he wants the case dropped.
I am disappointed, especially when I had the victim testify that he doesn't want to prosecute and he would like the charges dismissed, and that he wants my client released from jail, and that he has no fear. He's never had a problem with him before.
Despite that testimony, Marquise Gunter remains in jail on a $750,000 bond, a figure the defense calls excessive.
I don't think they'll ever get a conviction. They'll never get seat to 12 jurors to find my client guilty of what he's charged with.
Attorney Lonnie Spann says Gunter was protecting his mother from an ex-boyfriend who was told to leave their home several times. In a domestic violence situation, Gunter had just turned 18 with no criminal record.
And I feel like he is not being treated equally at all. And you got it from the victim that he did not want to press charges. He was just trying to defend his mama. That's all this baby been trying to do. This boy never been in trouble a day of his life.
A major point of contention, whether the gun used in the shooting was stolen.
The gun absolutely was not stolen.
But prosecutors argue Gunter changed multiple parts of his story from his initial interview with investigators.
You had an unarmed man that was shot without provocation with a firearm multiple times. The state's contention on stand your ground, as we demonstrated at the hearing today, is that the gun had been stolen and that he was in the midst of an unlawful act, and therefore he's not eligible for it.
DA Andy Hamlin says he plans to meet with the victim.
So if he continues to say he doesn't want to move forward, will that have a big impact on what you decide?
Well, like with any victim, we're going to be respectful for what their wishes are, but there has to be consequences.
For an outside perspective, we asked defense attorney Richard Jaffe, with nearly 50 years courtroom experience, about the unusually high bond.
It's the same as no bond. There's not a dime's worth of difference between $750,000 and no bond.
Under Alabama's rules of criminal procedure, the recommended bond for assault first degree is $5,000 to $30,000. Jaffe explains Gunter's bond can be appealed to the 11th Circuit.
A habeas corpus, that he is being unlawfully detained in violation of the 8th Amendment and the Alabama Constitution. It's not uncommon to file those when it's that much out of range.
And what about those incriminating statements Gunter made to police? Gunter was read his rights but did not have an attorney present.
Even so, you're still presumed innocent and you are supposed to be granted a reasonable bail.
If Judge Samuel Junkin grants the stand your ground motion, Gunter would have complete immunity from state, civil, and federal prosecution.
It saves enormous amounts of judicial and financial resources.
It's similar to self-defense. You must prove you didn't provoke the confrontation and were in reasonable fear of serious bodily harm or death. Newer laws do not require you to retreat if there's a danger. But Gunter's attorney Lonnie Spann says he is not optimistic about a stand your ground dismissal under Judge Junkin. Spann says he is now negotiating with the DA for either a misdemeanor or a youthful offender status, options that would allow Gunter to avoid a felony conviction. For the I-Team, I'm Cynthia Gould.